Question is the bill be now read the second time. The honourable member for Nelson.
Thank you, Mr President. Well, here we go again. An undignified stagger to the bottom of the legislative responsibility heap again. And I have to say at the outset, I do not understand this government's obsession with attempting to usurp the role of our judicial courts. Why must they insist on inserting themselves and telling other professionals how to do their job? To be frank, the government could do with focusing a bit more stringently on how it executes its own roles and responsibilities, rather than inserting themselves into our judicial responsibilities and roles. It would be a fair call, I think, for those in the judicial fraternity to tell the government to focus on its own job instead of meddling in theirs. But to this bill, whatever the impetus for this bill, it must be acknowledged that there was a public consultation process on the draft bill conducted by the Department of Justice, and I've got a bit to say about that. The consultation period opened on the 10th of February this year. It spanned the early state election period and it closed on the 29th of March, 10th of February to 29th of March. The election was called the 16th of February, I believe, and was held on the 23rd of March, so virtually the whole period. 8 public submissions were made in that consultation period, and those have been published on the Department of Justice's website. Of those 8 received submissions, only 1 presented the views of the legal fraternity, and that was from the community legal centres, which I'll discuss in further detail a little later. I'm surprised, and I suspect the department was surprised, that there weren't more submissions from the legal fraternity and legal bodies representing that fraternity received during that public consultation stage. And it's interesting to ask why. And I did ask why in the briefing. And I wonder whether it's because normally what would happen, we're given to believe, when we discussed this during the briefing, when the Department of Justice puts an exposure draft out for comment, there would be an automatic email go to 50 stakeholders or thereabouts, inviting them or making them aware of the consultation. In the case of this bill, that's not what happened, because before that could happen, caretaker period kicked in and advice from DPAC was given that it wouldn't be appropriate to send that email out as part of this consultation period. So the usual invitation didn't occur. One has to wonder then to what degree relevant stakeholders weren't aware that it was occurring, given all the other political activity across an election period called early and being held. And it's probably not surprising then that apparently close to the end of that consultation period, probably just after we got out of caretaker period, I imagine, there was a quick reach out to a couple of legal fraternity people, apparently the Law Society and Tas Legal Aid, that was confirmed. And that was right near the end of the period, didn't result in submissions. Probably not surprising, it's hard to turn around a submission on short notice for those bodies. I think this is utterly unacceptable, Mr President. I don't know why, if a consultation period was begun and then almost immediately a caretaker period was entered into, which meant that the usual processes of connecting with stakeholders couldn't be undertaken, why wasn't that just paused? Why wasn't it just paused and then done fully after the election was held? I think that's utterly unacceptable. I'm disturbed that we haven't had more formal submissions on this during that consultation period from the legal fraternity. And no doubt they would have echoed what we've heard time and time again in other instances on similar bills relating to mandatory sentencing. And yes, this is presumptive sentencing, but it's virtually the same principles being applied and the same objections would be applied. And I suspect we would have heard exactly those same objections brought by the legal fraternity on this bill. The other, I guess, possibility is, because I've had this put to me by stakeholders, actually in relation to engaging in consultations on bills of this sort and issues of this sort with this government, some stakeholders simply get tired of investing time and energy, stating their respective cases in submissions, putting time and effort into it, providing evidence-based submissions, making reasonable requests for changes to be considered based on those evidence-based presentations, only to be ignored. Ignored, 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 no changes made. It's not surprising that there'd be stakeholders making this case to me that they see it as absolutely pointless to engage with this government on any piece of legislation, this one probably included, when anything that they put forward as experts in their field, as people with valuable policy advice to provide, with evidence-based submissions made, absolutely no response, no taking on of any of that expert advice from community stakeholders, except the ones the government intended to take on in the first place. And I'm not surprised that we seem to have submissions here in this consultation process from very interested stakeholders who support the government's position. Did they get a communication to alert them to the consultation? I wonder, Mr President, perhaps the government can provide an answer to that in the summing up. Did a communication go out to any stakeholders, including the ones who made submissions in support of the bill, to those stakeholders from the Department of Justice prior to being told not to during the caretaker period, reach out to other stakeholders? Or did the government itself or members of the government, or then, once the election was called, candidates for the government, send alerts out to those stakeholders? That would be interesting to know, I think, in this case. Anyhow, Mr President, yes, there certainly were submissions received from certain stakeholders who perceive that they will benefit from this bill. And oh my goodness, how mistaken they are. It's really sad, I think, the degree to which we're seeing a misleading approach here from the government. And I did ask the government in terms of what they had given stakeholders an expectation of in terms of impact of this bill. Had they led people to believe that a bill of this sort would address their very valid concerns about safety of staff in various industries and various positions? Because none of us are going to disagree that there's some people in roles in certain industries that absolutely may well be subject to risk in their interactions with the public. Did the government tell people, stakeholders, that they could expect that a bill of this sort would better protect their workers, would result in a decrease in risk and or tangible assaults occurring? I asked in the briefing, Mr President, if they gave that expectation to stakeholders, and it came back to me that no, they hadn't given that expectation to stakeholders at all. They hadn't told them that there would be that impact from the bill, and that's because they couldn't, Mr President, because all evidence says it won't cause an improvement in those things. But I think that those stakeholders may well have been led to believe that talking tough means something tangible will happen in terms of an improvement in safety and an improvement in the number of potential assaults occurring. How sad. How sad that they may have been misled by that bluff, that talking tough actually means results. Because with this government, that's certainly not what the evidence tells us. Mr President, I'm going to reflect on the submission from the Community Legal Centres Tasmania, which was the only legal fraternity body that sent something through during the consultation process. The submission was very useful in that it provides some evidence-based argument regarding the assertion that mandatory sentencing, and I'm going to say mandatory sentencing / presumptive sentencing because it's the same principles behind both, constraining the judicial officers in undertaking their role. Regarding the assertion that mandatory sentencing provides an effective deterrent. The CLC submission provides a graph presenting Tasmanian police data following the 2014 amendment to Section 16A of the Sentencing Act 1997, which introduced minimum mandatory sentences of 6 months where an offender is convicted of an assault which causes serious bodily harm to a police officer on duty unless there are exceptional circumstances. The graph in the submission shows over the last decade the number of police officers in Tasmania has increased by 15%, whilst the number of assaults against police officers has increased by 27%. Minimum mandatory sentencing, not quite the effective deterrent then, Mr President. However, since 2020, the data shows the number of serious assaults against police officers has reduced, while the CLC contends may be explained by the introduction of body-worn cameras in July 2020, citing the fact that when introducing the reform, the then Minister for Police, Fire and Emergency Management acknowledged that body-worn cameras provide significant operational benefits, including positively influencing the behaviours of people interacting with police and reducing the number of assaults against police. Look at that, Mr President, evidence-based initiative and reform that then resulted in an expected and anticipated positive impact, reducing the number of assaults occurring. That's what happens when you use evidence to inform where you're going with these sorts of reforms. That's why it makes a nonsense of tough on crime. Tough on crime is dumb on crime, Mr. President. What we need is smart on crime, which means evidence-based. To suggest to the community that tough on crime is going to make them safer is a lie. That's what this government engages in when it suggests to the community that they're tough on crime and their non-evidence-based measures are going to make the community safer. They're lying. Thank you. The CLC puts a strong case based on the data. It's clear the introduction of Section 16A of the Sentencing Act 1997 has had no significant deterrent effect on police officer assaults in Tasmania. And further, this submission points to academic research carried out examining minimum mandatory sentencing offences in other Australian jurisdictions, which has also concluded that minimum mandatory sentencing is not an effective deterrent. TASCOS also provided a submission, and in its submission also states that peak organisation's opposition to the use of mandatory and presumptive sentencing legislation. TASCOS draws our attention to the following statement by the Law Council of Australia, and I quote, "There is a lack of persuasive evidence to suggest that the justifications often given for mandatory sentences, retribution, effective deterrence, incapacitation, denunciation and consistency, achieve the intended aim. Instead, mandatory sentencing regimes can produce unjust results with significant economic and social costs without a clear and directly attributable corresponding benefit in crime reduction. Further, mandatory sentencing schemes undermine community confidence in judges to administer justice and deliver appropriate sentences." I think that's fascinating, Mr. President, that quote from the Law Council of Australia. This is making it very clear that this sort of non-evidence-based, lying tough on crime approach actually undermines community confidence in our judicial system. Rather than builds it, it undermines it. Of course, we could take different actions to build it up, but we don't. Further, TASCOS cites other legal organisations such as the Law Institute of Victoria, which have stated that minimum sentencing regimes do not reduce crime rates. The Law Society of Western Australia argues there is no evidence that it works to deter criminal behaviour and is more likely to result in harsh and disproportionate sentences. Similarly, there's little evidence, for example, from jurisdictions with mandatory penalties for similar offences, that the introduction of mandatory sentencing against emergency service workers has resulted in a reduction in this type of offence. Mr. President, another serious concern is the known disproportional impact that mandatory sentencing has upon our Tasmanian Aboriginal community and other vulnerable sectors of the community. The CLC submission points to the fact that mandatory and prescribed minimum sentences disproportionately affect Aboriginal and Torres Strait Islander community members. In Tasmania, 23% of the prison population is Aboriginal and Torres Strait Islander, while comprising 5% of the broader Tasmanian population. Over the last decade, Tasmania's prison population has increased by 30%, whilst the Aboriginal and Torres Strait Islander prisoner population has almost doubled, a 98% increase. The Community Legal Centres warns that the introduction of a prescribed minimum sentence is likely to disproportionately impact Aboriginal Tasmanians and contribute to increased incarceration rates as documented in other jurisdictions. Mr. President, we are already absolutely failing in our closing the gap efforts here. We are failing in that when it comes to our criminal justice system. This will make it worse. This is actually counter to our closing the gap commitments and responsibilities. TASCOS also reiterates and stresses their concern about disproportionate impact upon Aboriginal individuals and communities. In this context, TASCOS warns this, and I quote, "Expanding Tasmania's presumptive sentencing legislation will not address the systemic drivers of rising imprisonment rates, but will continue to funnel those experiencing disadvantage into cycles of imprisonment." We should not take that warning lightly, Mr. President. It is incumbent on us to heed this warning as a matter of serious social justice and human rights. TASCOS's submission highlights the need for us as a parliament and a community to investigate alternatives to mandatory sentencing or presumptive sentencing and to seek to divert people from the criminal justice system instead. There is merit to that argument, Mr President, because evidence tells us and demonstrates that diversionary options are both extremely cost-effective while also assisting in reducing recidivism rates. TASCOS states pretty emphatically, in fact, that rather than promoting mandatory and presumptive sentencing, if we were serious about increasing frontline worker and community safety, if this government was serious about that, it would prioritise and ensure policy and legislative reform is informed by evidence-based initiatives. Such alternatives, they've said, include better training and improved public education to reduce risks of assault and to achieve better outcomes than increased penalties. We need greater use of diversionary options and investment in addressing the drivers of offending, as evidence tells us that will be more cost-effective and reduce recidivism. In contrast, presumptive sentences do not address the causes of violence, and penalties for offenders are enforced after a worker has already been seriously assaulted. It's a post-fact effort, not preventative. It doesn't increase safety. TASCOS emphasises that system failures such as inadequate resourcing to support trauma-informed practice or investment in prevention and early intervention services will ensure that frontline workers and community members continue to be at high risk to acts of violence. Hence, it's not surprising that TASCOS submission recommends very bluntly two things. One, the Tasmanian Government withdraws this draft bill to prevent unjust sentencing provisions. And two, the Tasmanian Government works proactively to reduce contact with the criminal justice systems by increasing investment to expand diversionary options, adequately resource prevention and early intervention services, and address the drivers of offending. What a shame, Mr President, that those two very worthwhile recommendations from TASCOS that are evidence-based, that are smart on crime, were utterly ignored by this government. Hence, we have this incredibly flawed bill before us. As has been stated by the CLC and reiterated on the public record in the other place, there's a strong assessment that this bill will not deliver its stated intent. It will not help protect those selected designated groups of workers that are listed in it. As discussed previously, the CLC submission points to data indicating that since 2014 and the passing of Section 16A of the Sentencing Act, legislating minimum mandatory sentences of 6 months when an offender is convicted of an assault which causes serious bodily harm to a police officer on duty, unless there are exceptional circumstances, the expected correlation of reduced assaults on that category of frontline worker has not eventuated. Certainly not from that effort, but we have tackled it in other ways that appear to be significantly more effective. The CLC submission goes on to say, we strongly believe the bill will not protect either frontline workers or emergency service workers. The evidence demonstrates that the mandatory sentence provision already in place for assaults against police officers has not seen any decrease in assaults against police officers. There's no evidence that introducing presumptive minimum sentences for other occupations will have any deterrent effect. It doesn't make people safer, Mr President. It's as simple as that. Mr President, the other unnecessary and offensive aspect of this bill is the fact we already have assault and causing bodily harm provisions in our statutes. During the department's briefing, we discussed the fact we already have grievous bodily harm. We already have bodily harm. We've been given to believe that although it's not definitively defined, serious harm is going to fall somewhere between those two. Is it needed? It doesn't actually, there's not a case that's been made squarely that it is needed to add this extra and new understanding. The government has form in this regard when it comes to duplicating for the special few particular statutes, and we know that. I'm thinking, for example, of the draconian protest laws, which sadly passed this parliament, despite the fact we already had trespass provisions in our statutes and other ways to deal with lawful protest and people undertaking their rights to protest. I find this kind of duplication of provisions and offences already available in our statutes quite ironic, Mr President, particularly when it occurs under the auspices of a party which prides itself on anti-red tape. So, Mr President, there are some matters that came up in the briefing that I'd just like to touch on briefly that I thought were worth reflecting on when it comes to this bill. We always should start with the principle of what's the problem we're trying to solve. What information do we have about the effect we're trying to have here and what we want to change. I asked, have we reviewed previous mandatory sentencing laws in this state, the one that related to police officers that's been mentioned in my contribution already? No, we haven't reviewed that apparently because there wasn't enough data, hasn't been used enough for us to be able to review it. There's no baseline data on the groups that are included in this bill in terms of the sorts of assaults that would be captured by this bill. We don't have a baseline data set to tell us what the situation is now. So even though there's a review in this bill, we're going to be in a position of 5 years' time asking ourselves, what impact did this bill have? What changed after we introduced it? And we're going to be scratching our heads because we didn't start from a position of a baseline that we could then compare to. In fact, when we discussed it in the briefing, it was pointed out the reviewer at that point in time may well have to go back themselves then to try to scrape together some form of baseline for this point in time at the start of this bill's life, this Act's life, if it passes, to be able to compare changes over time. How ridiculous. If a reviewer's got to do that in 5 years' time, why didn't the government bother to do it now, before bringing this bill? Put together the evidence base, give us the baseline data, so we know what this looks like for the groups described and listed in the bill. What does it look like in terms of serious assaults or serious harm as a result of assaults that would be captured by this bill? We just simply don't have it there as evidence. We're told, as I mentioned earlier, that those stakeholders who have been approaching the government with their concerns about safety for workers, and those, as I've said, justifiable concerns, everybody wants people to be safe at work and to be able to go home safe at the end of a work day. And when people have come to the government and stakeholders and industries have come to the government with those concerns, has the government given them the expectation that this bill is going to help? Apparently not. I wonder what they have said to them about the expected impact of this bill. When I've asked what the expectation was around the impact of this bill, apparently it's that the community at large, for the community at large, it will have an educative function. It will indicate how seriously we take the safety of frontline workers listed in this bill. Now that's absolutely fine, Mr. President, but of course, we don't hold those particular groups above all other Tasmanian workers in terms of their safety. And as the member for Launceston so correctly pointed out, there's absolutely no need to make a list, because as soon as you do that, it's exclusive rather than inclusive, and we've put some above others. And of course our concern is extended to all Tasmanian workers. How will we know if this bill should pass and become law? How will we know whether it has reduced assaults? Do we expect it to reduce assaults, actually? And the answer to that, the short answer to that is we won't know if it has, because we don't have the baseline data. The other thing about this, Mr. President, that I think would have been absolutely basic to accept from the government in terms of information to give us to make the case for this bill, is we don't know whether the court are currently sentencing in line with this. Is this going to actually ask the court and the judicial officers to do anything different to what they already do in circumstances that would be captured by this bill that are occurring right now? We actually haven't put that information together to tell us that. So we could very well have a situation where our judicial officers are sentencing exactly in line with what's asked in this bill. That this is actually BAU, business as usual, right now in our courts, in which case it's thoroughly unnecessary. But we don't have the data to tell us that, because the government haven't bothered to go back through and actually put together a case for whether or not this is needed and warranted. That's just ridiculous. That is poor public policy. It's absolutely ridiculous to be bringing us a piece of legislation that has literally no evidence base to support it. The interesting thing I find, Mr. President, when we start bandying about statements about meeting community expectations when it comes to our criminal justice system, I find it really ironic. Because here's the facts about this. There is often, I think we would probably all have heard this, and I think it's true, there's often a community perception that sentencing by our judicial officers is too light, and that's not just limited to Tasmania, that's actually quite a common in other jurisdictions as well, and actually globally. Community perception often thinks just judges let people off too lightly. Here's what's happened when academic researchers have looked into that and examined that in more detail. Typically what happens then is when researchers say, okay, here they research members of the public who think sentencing is too light. They take those members of the public then and they familiarise them with actual case examples. And they walk them through the full information of the case and the explanation for why the judicial officers gave the sentences they gave in those cases. And you know what happens at the end of it? The community members largely either agree with the judicial officers or think the sentence should have been lighter. That's what happens. That's what's come out of the research. I wish I could quote it to you, Mr. President. I'll have to go and look it up so next time I can actually quote the specific research that indicates this. What that tells me is when that community perception is present that our judicial system is sentencing too lightly, the solution to that is education, not inflammation. This sort of bill inflames that perception. It's a false perception, Mr. President, because when people are educated, they actually typically change their mind and actually builds confidence in the public for our judicial system and for our judicial officers and the decisions they're making with their expert role in sentencing people in that system. Education builds public confidence in our judicial system. Education helps quiet and quell community concern and perceptions about sentencing. This kind of bill is running in the opposite direction. It's inflammation. It's actually politically self-interested inflammation by this government of community fears and concerns. How disgraceful. Utterly disgraceful. Before I close, Mr. President, I wish to take the opportunity to place on the record here my deep concern and disquiet regarding the sudden proliferation of mandatory/presumptive sentencing legislation coming through this parliament. Previous parliaments certainly had attempts placed before them, but at the time, common sense and respect for the separation of parliamentary and judicial powers had been, in the main, upheld by the opposition parties, particularly in the other place. Recently, and inexplicably, the Tasmanian Labor Party appears to have abandoned its long-held practice of standing firm against mandatory minimum sentencing/presumptive sentencing of all sorts. It has not gone unnoticed that despite abandoning its former in-principle evidence-based position, more often than not, the Labor Party takes great pains to state it does not believe the mandatory sentencing bill will actually deliver its stated intended aims, that it is going to be ineffectual and it won't deliver. Specifically, that argument was prosecuted for this particular bill in the other place, but that is no excuse for facilitating the passage of bad law. We all in this parliament, no matter whether party affiliated or independent, have a fundamental responsibility to deliver to the best of our ability good, fair and functioning laws. Traditionally, this is particularly pertinent to a core responsibility of this chamber as a designated House of Review. We are charged to scrutinise proposed legislation not solely for delivery of policy aims, but also that the legislation is workable and is good law. I urge the honourable members here to seriously consider the fact that despite the majority consensus as expressed during the debate in the other place, that this bill will be ineffective, that it will not deliver the stated intent due to the evidence-based recognition that mandatory sentencing is wildly ineffective as a deterrent tool. Despite all that being placed on the public record, a flawed and bad piece of proposed law has been placed before this place to consider because it was passed, despite all those things being expressed in the other place by the majority of members there. In any other professional capacity, the recipients of a flawed, in principally wrong and bad proposal would be justified in thinking, how dare they?